to Know law is free, and it's not. So we're going to talk about the payment side of this as it relates, pardon me, both to agencies and to requesters. Couple preliminaries before we jump into the presentation itself. What you're seeing is a PowerPoint presentation. These PowerPoint files are available on our website. Go over to the training tab, scroll down, and you'll find all of the PowerPoints that we use for our training, and you're welcome to download those as you see fit. It may be that you have a friend or colleague who couldn't attend this morning, and it would be helpful for them to get caught up. You might just want it for your own future reference, or perhaps you're conducting some localized training and you need some material, and feel free to plagiarize us. We consider it all public records, and you can download it for free and use it as you see fit. Okay. The other thing is that this session is being recorded, and again, as with the PowerPoints, the recordings are available to you within a couple days. A link will be posted on the website, again, under the training tab, or if need be, you can contact the office directly and they can email you a link into our database that would get you access to the recording. If you have questions, feel free to use the chat feature to type in your questions, and I'll do my best to answer them live as we're going through the presentation. Two things though. First is, we're talking about the right to know law, we're talking about payment issues. So let's do our best to stay on topic. The other thing is that the more concise and direct you can keep your questions short, the better. Occasionally, folks will type in several paragraphs, and it just gets very awkward for me to sit here, read through that while everyone else is waiting patiently and listening to the dead air time. So the more concise and direct you can keep your questions, the better. If you have a situation where it's unique to your particular set of circumstances, or it's just unusually complex, we'll do one of two things. We'll wait until the end of the presentation and I'll try to come back to it and answer it for the good of the order, or we'll take the conversation offline. There is contact information for the office on the screen right now. You can call in or you can send us an email. Excuse me. And initially it goes to one of our administrative staff who are very well versed in the right to know law and can usually get you headed in the right direction. If you happen to stump that panel, we escalate your question to one of the senior staff, and they'll do their best to get back to you as soon as possible. A couple things: we cannot write requests for you. We cannot answer requests for you. We can't discuss any active appeals that would happen to be before our office, and we cannot provide legal advice. That's between you and your attorney or solicitor or whomever. But we have well over 30,000 decisions that we've issued since the office first opened, and they are all online in a searchable database. And there's a very good chance that whatever you're asking us about, we've seen before. And we can direct you to that database, and we might even be able to rattle off some case citations off the top of our heads to suggest you read a decision where the factual and legal circumstances are very similar to what you're telling us about. Okay, I think that takes care of all the preliminaries. Let's jump into this and talk about payment issues. The right to know law in Section 1307 gives the Office of Open Records the responsibility of establishing a fee schedule. That is posted on our website, and it is reviewed every 2 years and amended as deemed necessary. Prior to it being amended, we use social media and other outlets to solicit comments from any interested parties, agencies, and the public. And I can tell you from personal experience that we have changed the fee schedule as a result of concerns raised by members of the public and agencies. I think that review might be coming up next year in 2025. I would have to confirm that. But keep an ear out for solicitations if you have concerns about charges related to the right to know law. In a nutshell, it's 25 cents a page, single-sided, black and white, 8.5 by 11 or 8.5 by 14. If by chance you're getting color copies or colors involved, then it goes up to 50 cents a page. Any other size of hard copy document typically would be the actual cost. And that can be calculated in a couple different ways. You may have a large scale copier available in your agency. And in some instances, it's leased. And for large scale pages, there is a per page charge. If you can document the actual cost, then that cost can be passed on to the requester. And if you would have to go outside of the office to make a copy, like say you could have Kinko's or one of the other copier services, the Office Max and that kind of place, whatever they would charge, the agency could then turn around and pass that charge on to the requester. You see the asterisk there. This actually was a result of a review of the fee schedule, and someone suggested this. We took a look at it and agreed. If it is a particularly large response that exceeds 1,000 pages, once you get above 1,000, the maximum cost drops to 20 cents a page as opposed to the 25. And I want to emphasize that fact that it is up to 25 cents a page. There's nothing in the law that says you must charge 25 cents a page. It just says it establishes a maximum. For instance, in most cases, the Office of Open Records, now most of our responses are electronic because the office runs essentially electronic. You're not going to find a lot of printed documents here at the office. But when we do have to make hard copies and send them out, typically we don't charge at all. It's just when you get into the invoicing side of it, it actually costs us more to generate invoices and process payments and so forth. So it's a rare day when the Office of Open Records actually charges for records. But it's been known to happen, and I'm not saying that's what you should do. I'm just saying, using that as an example where while we can charge up to 25 cents a page, we choose not to charge anything at all in most cases. Now, looking at the fee schedule, you're going to see the basics, like I just pointed out, and some other things about, electronic media and so forth. But then down at the bottom, you're going to see in fine print footnotes. Folks, read the footnotes, okay? It's important because with everything, you're going to find exceptions. And then there's exceptions to the exceptions. And because the right to know law has been around now for 14 years, there is a fair body of case law that deals with the fee schedule, okay? Because you can appeal disagreements over how much you should be charged for records. So the decisions in that case law oftentimes are reflected in the explanations and exceptions that are detailed in the footnotes. For instance, you can get into an area of the law called redaction, where you're releasing a public record, but on that public record, there is some sensitive piece of data that needs to be removed. Okay, that's called redaction. Well, there are some limited instances where you can charge as a result of having to do a redaction. Okay, now not every time, it depends on a number of circumstances, but that's just one example where it's explained in the footnotes. And there's case citations and the like. So if you want to fully understand what an agency can legally charge for and what they can't charge for, I would suggest reading the footnotes, okay? It's not exciting reading, granted, but it helps explain why agencies do what they do when they're calculating how much they can charge a requester for a granted response. Okay, let's move on. Yeah, I use the term actual costs, or another term is pass-through costs. And like I explained in the previous slide, it's when the agency can actually document an actual cost. And a very clear example is postage. And let's say the scenario is someone submits a right to know request for hard copy records. The agency goes ahead and produces those copies. And let's say they charge 25 cents a page. Okay, that's one part of the cost. But then the requester would like the package mailed to them, and they provide a mailing address. Okay, so the agency then takes the copies, puts it on their postage meter, and let's say it generates a cost of $3.15 for postage. Okay, that is an actual pass-through cost. The agency on its postage meter has documentation that says it's going to cost $3.15 to mail this packet of records to the requester. So they can add that $3.15 onto the invoice. Okay, that is a pass-through cost or an actual cost. I mentioned, going down to Kinko's or Staples to have larger copies made, like blueprints are a good example. Occasionally there will be a works project where blueprints are generated and they're part of the public record and someone requests them for whatever reason. So the agency, let's say they don't have a large scale copier, they got to go out and they're charged, I don't know, $10 per sheet. I haven't checked what the costs are lately. But because they now have a receipt for what it costs them to generate those copies of the blueprints, they can add that on to the invoice, okay, outside copying fees. Analog recordings, here we're talking about cassette tapes, and I don't even know if they're even still used. I'm guessing probably somewhere. Most recordings nowadays are digital. But we used to have those double cassette decks, okay? I had one at home that I think it died 10 years ago, and I don't think you're going to find a cassette tape in our house anywhere. But, they may still be around. Well, if someone were to request a recording, let's say of a public meeting that the agency produced, they wouldn't be able to do it in-house because they don't have that cassette, that double cassette deck. So maybe they need to go to an electronics store. Maybe they need to go to a recording studio. I don't know. But, whatever they're charged to produce a copy of that cassette tape, they could pass on to the requester in that particular case. And then we're talking about digital storage media like flash drives. If the agency has to, and this would happen usually with larger responses, big files that for whatever reason can't be emailed. For instance, here at the Office of Open Records, we rely on the state's email system that has a maximum size for attachments. Okay, well, when we encounter that, every so often, now usually what we do is break it down into multiple emails, but there were times where the easiest thing to do was simply put the file on a large flash drive and send it out the door through the mail or whatever. Well, you can charge for those flash drives, But in the next slide here, I think I'm going to talk about maybe something that you want to consider if you're still doing that. If you're keeping a supply of flash drives and then you have to charge the requester for the cost of that flash drive, there might be an easier way to handle this. But again, that's up to you. Okay, but let's take a look at that. And this is what we call a best practice. This was brought to our attention several years ago by a couple of townships and boroughs who, pardon me, had adopted this practice after taking a look at, primarily for computer security reasons. But then it turned out it was easier for them to do this anyway. It saved work in the long run. But what they are doing, and I want to emphasize, this is purely a best practice. There's nothing in the law, nothing in our policy that says you must do this. We're simply pointing this out that we think it's a good idea, so we're telling everybody about it. But rather than have someone, or rather than keep a supply of flash drives, or have someone come in with a flash drive that you don't know what's on there and ask for an electronic copy, the practice is that when they grant a request for electronic records and the individual wants them put on a flash drive, they tell the person, okay, send us a new unopened flash drive. And that satisfies the computer people who are concerned about viruses and malware and so forth. Then what they'll do, what the agency does, is they take the files in question, copy them over to a laptop, and then unplug the laptop from their computer network. Then they take the new flash drive, plug it into the laptop, and if by chance there's anything unusual with the flash drive, the laptop's computer virus software picks it up without any fear of it infecting the network. Okay, and then the files are copied over to the flash drive, and that's taken out and given back to the requester. And that takes care of the security aspect of it, plus it eliminates the need for the agency to keep a supply of flash drives. And usually, because you're dealing with electronic records, since there's typically no charges, now you don't have to worry about invoicing and processing payments for the flash drives because the requester supplied it. Okay, and like I said, this seems to work for these other townships and boroughs, and maybe you want to consider that if you're not doing it at this point. Okay, there are things that you can't charge for, and this is in the law. You can't charge for labor, and I know that this is a touchy area with agencies, but it's just considered the cost of doing business for a government agency when processing right-to-know requests. So no hourly fees or no fixed fees. And we still find agency websites out there where they're attempting to charge a fixed fee to respond to right-to-know requests. And we have to, well, first offhand, every so often it gets appealed to our office, and we have to issue an order saying you're not allowed to charge a fee. And periodically, when we have time, which doesn't happen often lately, we will scan agency websites, and if we find language like this, we'll reach out to them with a letter saying, hey, you're out of compliance with the law, you're not allowed to charge these fees. You can't charge for legal review, whether it be internal counsel, like your solicitor, or some form of outside counsel. No sort of processing fee, no sort of redaction fee. Occasionally, we'll see that. It's like, if we have to perform any redactions on your response, we're going to charge you an extra $10. No, you're not allowed to do that. Scanning fees. Okay, now I haven't heard this in a couple of years, but back in the day, I would say once a month, I would get an email or a phone call from somebody saying, look, with our copier, scanning puts the same wear and tear and the same amount of labor that copying does. So why can't we charge for scanning in records? Okay, well, you can't. There's no charge for electronic records. And I'm going to get into it here a little later, but chances are you don't have to scan. All right, and I'm going to explain that like I promised here. But if you have concerns over why you can't charge for scanning, I'm going to ask you, why are you scanning in the first place? Okay, and you'll see why when I get into that. And no, you cannot charge for electricity. My first question to those people is, how would you do that? And like I said earlier, you can't charge for electronic records, such as emails, Word documents, Excel spreadsheets, various database files. Now, if there is a dispute over the fees that an agency is charging and the requester disagrees with it, that can be appealed. And I mentioned our final determinations database. Well, that is a record of all the appeals that our office has processed. It's a searchable database. So you can go in and there's one field where you can just put in a random phrase. So put in the phrase fee, F-E-E, and a couple dozen decisions will come up where there was a dispute over fees that an agency charged, and either our office or a higher court issued a ruling on that particular set of circumstances. So yes, if there is a dispute over fees, that's considered a denial, and it can be appealed to our office. Let me get a sip of coffee here before we move on. Yeah, here's where I'm going to talk about the scanning aspect, like I promised. This is interesting, and it's an important point for agencies. It's also an important point for requesters to understand why agencies might do what they do. But in Section 701 of the law, to paraphrase here, the agency is only required to provide the record in the medium in which it exists, okay? To translate that to English, it means hard copy versus electronic. Those are the mediums. You have a hard copy record, which is typically a piece of paper, or you have an electronic record, which is, a digital message, such as an email, Word document, or the like. So where this comes into play is if the agency only has records in hard copy medium. Let me throw out an example here. Let's say it's building code enforcement and submitting requests for building permits, okay? It's an entirely paper-driven process in this imaginary jurisdiction. So I submit my application, it goes into codes enforcement, any communication back and forth is by letter and snail mail, and then once it's approved, they issue a paper document, and everything ends up going into a file folder, kept in a file cabinet. All right, so someone submits a right to know request for a copy of the building permit, the approved permit, and all associated files. And they want it sent to them electronically. Well, they do that for two reasons. One, because it's easy, and two, because it's free. You cannot charge for electronic records. But because everything is hard copy, Section 701 essentially is saying you don't have to scan those records in, because that would be converting them from hard copy medium to electronic medium. And you only need to provide the records in the medium in which the records exist. So the agency's response would be, yes, we have those records, but they're hard copy. We're happy to provide them to you, but it's going to cost you, 25 cents a page or whatever your charge is. And this is what the total would be. Are you willing to pay that? And then the requester then has a decision to make. Are they willing to pay that nominal fee for the file that they've requested? If not, tough luck. They can appeal it, but typically the agency would win out in that particular scenario. Okay, so the bottom line here is that agencies don't usually have to scan. Okay, so that, and like I said, I haven't heard the complaint about that in a couple of years. I think people have either resigned themselves to thinking that they can't charge, or maybe now they understand that they don't have to scan. But I just want to get that point across because there are a number of, there's always new people coming into the process, and I want to make sure everyone understands that. Now, let's talk about medium versus format. Okay, medium is hard copy and electronic. Format deals solely with electronic, but you've got different software programs that generate electronic records in different formats. For instance, this morning I was dealing with, actually it was last night, I was dealing with JPEG files, which are pictures, and PDF files, which are kind of like pictures, but they're different, okay? And I was having trouble emailing somebody some documents. Actually, I was doing this at home. Having trouble emailing someone some documents because I got the two mixed up. I thought I was emailing PDF attachments when in fact they were JPEG attachments, and I had to convert them, and that took an extra 15 minutes. But there I was dealing with formats, okay? So why am I talking about this? Well, there is a legal issue where if someone requests a spreadsheet, agencies used to be concerned, and I haven't heard this concern in a while, but it's still out there. Agencies used to be concerned that if we provide the Excel spreadsheet, then that has the formulas that support what you see in the cells, and those formulas are secret, or someone can go in and alter the spreadsheet and misrepresent what we gave them. Well, I'm not aware of that ever actually happening. And if it did happen, it wouldn't be a right to know issue. It would be another legal issue that the agency could take action against the person that misrepresented. But that's, that's a legal issue that our office and I'm not going to get involved with. So the agency, rather than send the Excel spreadsheet, would send an electronic PDF copy. Okay, and Excel allows you to do that. Generate, you hit print and then you have choices. Well, or save, and we're gonna save it as PDF, and then we're gonna provide that. Well, that got appealed, okay? Whoever the requester was said, hey, I requested the spreadsheet, not a PDF file. Now, back 10 years ago, the court said, look, the right to know law says you have to provide a copy of the original. PDF is a copy, so that's acceptable. Now, since then, the courts have shifted a little bit. And where we're at today is that if someone requests a spreadsheet, if they just ask for the spreadsheet, you can give them PDF. If they say, I want a copy of the Excel spreadsheet, then that's what you have to provide, okay? You give them exactly what they're asking for. And honestly, like I said, I'm not aware of anyone ever taking a record, altering it, and misrepresenting what the agency provided. So, it might be one of those unfounded fears anyway. But that's where the law is today. And then occasionally we run across proprietary formats. This is where you've got a custom piece of software. There are some record-keeping packages for law enforcement that cannot generate any sort of file that is readable if you don't have a copy of the software. Like you can't generate an ASCII file or a CSV file or an Excel file for that matter. You only can read the output if you have a copy of the proprietary software. if that's the case, then the agency gets a pass because they can say we're unable to generate the record in a copy that the public can understand. All right, I have not run across this in a couple of years, but it used to be out there. And I think what's happened is, you know, the vendors have seen a need. Yeah, we need to be able to generate public readable reports. So they've added that functionality to newer versions of their proprietary software packages. But just in case you run across that. All right, redaction costs. If you remember, in pointing out what agencies cannot charge for, I said you cannot charge a redaction fee, but there may be circumstances where an agency can charge as the result of doing redaction. And let me explain how that all would work. The agency receives a right to know request. They end up granting it. Okay, they're saying this is a public record, but on that public record, there's some sensitive piece of data that is confidential. For instance, it could be a home email address or a personal email address or a home phone number or a social security number. Okay, so what they need to do is remove that in some way from the record. Now, let's say it's an electronic record. Originally, I said you can't charge for electronic records and you can't charge for redaction. But in this particular instance, there's two things that the agency can do. One is that if they have electronic redaction software, for instance, the Adobe Office Suite, that has functionality that's been approved by the FBI, it's considered secure, where you can go in and electronically remove fields from the electronic record and then send it on its way as a redacted document. But if you don't have that software, the option available to you is a manual redaction. So you end up printing the electronic record out, then you take your Sharpie or white out or whatever and black out or white out the social security number, then you scan it back in and send the redacted document to the requester. Okay, if you end up printing out that record, you can charge for the piece of paper that you had to print out to generate the redacted record that you then scan back in. Okay, so you see the exception that's taking place here. Number one, you are able to charge for a redaction. Number two, you're scanning. Okay, and you can that ends up you assessing a charge because of that exercise. That's an example. That happens more often than you realize for charging for a redaction. Now, where we're at currently is our policy is that if you have redaction software, you should use it. Okay, notice it's italicized. It's should, not shall. Okay, we're not saying you must use it. We're just saying you oughta, if that makes sense. Okay, however, we're getting a sense from the courts that probably within the next, I'm going to say 2 years, because nothing moves fast with the courts, that will change to shall. Okay, it's our belief that somewhere along the line, someone's going to appeal this, and it's going to make it up into the courts where a decision will be issued, where the courts are going to say, look, if you have redaction software, you have to use it, and you cannot charge for the electronic redaction. Okay? Now, at the end of the slide here, let me point this out. Anytime you redact on an otherwise public record, number one, in your response letter, you should point out that there's a redaction. Tell the person what's behind that black square. If it's a social security number, Okay, that way they'll understand why it's being redacted, okay, because that's considered confidential. Same way with email addresses and phone numbers and the like. You tell the person what's behind the redaction, not specifically, but in general terms. And then if that person disagrees with the redaction, they can appeal that, because essentially you are denying them access to whatever's behind that redacted piece of information. Okay, and we have a series of decisions that deal specifically with redactions that you can kind of get yourself up to speed with if you need be. But in many instances, those appeals can be avoided if you just tell the person why you redacted what you did, and you can move on. Okay, what about actually charging fees? Let me start by pointing out a section of the law, section 901, where you can kind of guarantee payment before you even begin processing. And this is, this is section 1307H actually, where let's say you receive a right to know request and you take a look at the potential response. You do a quick estimate, and it's going to exceed $100 because it's a really big response. And this happens like when you get requests concerning right-of-way, construction projects and the like, environmental impact studies, and so forth. I mean, yeah. So what the law allows you to do is to reach out before you even begin processing the request. Reach out to the requester and say, this is going to cost, X number of dollars in excess of 100. So you can demand a payment up front for the estimated cost that exceeds $100 before you even begin processing payment or processing the request. I, like I said, view this as a security deposit that's built into the law so that you don't get stiffed for all that work and copies you've generated if the person should happen to balk at making payment. You get the payment up front. They send you a check. You wait for the check to clear the bank. And when you're sure that the funds are then available, then you begin processing the request. And let's say it's a little low or it's a little high when it comes time for the actual provision of the records. Well, you settle up at that point, okay? This is built into the law and you can use it at your discretion. Now, here's what I think is the most important aspect of this slide, and it doesn't just apply to responses that would be in excess of $100. It's, if you're familiar with the right to know law, there are hard deadlines built into this. And if you've been through the basics webinar, you're familiar with what I'm talking about. You've got the 5 business days and then the option of the 30 calendar day extension. Okay. The deadlines are placed upon the agency to provide the response. Okay. The word is response, not records. Okay. And there's a lot of misunderstanding about that. People think that I submit the right to know request and the agency is required to give me the records within 5 business days. No. Read the law. It says they're required to provide you with an initial response within the 5 business days. The records might come later. And they would especially come later if they're hard copy and there's payment involved. So what they're obligated to do, and let's say everything takes place within the 5 business days. They grant the request, then they generate a response. They generate a letter that gets sent out to the requester within the deadlines. They're saying, we're granting your request, and because it's hard copy, we're charging 25 cents a page. It's going, here's the total. Send us a check And when your check clears, we will then provide you with the records. And that can be outside of the 5 business days. Okay, and typically it's, a reasonable period of time. Granted, that's a subjective term, but typically it's 2 or 3 days, a reasonable period of time to get the records together, generate the copies, and mail them out to the requester, if that's how the transaction is going to take place. Okay, so same way if they would happen to use the extension. The language in the extension says that the agency would then provide a final response before the end of the 30 calendar days. Okay, response, not records. So there could be additional time based on the person providing the payment. Maybe they have to mail the check in. Then the agency is going to take time to get that check down to the bank and then get confirmation a couple days later that it cleared, and then a couple days to actually mail out the records back to the requester. And who knows how long the mails are going to take. So yeah, you could have significantly more time involved in a requester actually having the records in hand, as opposed to the deadlines built into the law, which deal only with the response, not the actual provision of the records. Okay, again, it's a fairly common misunderstanding that hopefully now everyone is straight on. Okay, record discard. I don't want to spend a whole lot of time on this because it doesn't come up that often anymore. But basically, what this is saying is that if someone submits a right to know request and it's granted, and the agency provides the grant letter, they generate the copies, and it's their understanding that the person is going to pay, and then they don't pay. Let's say the money never comes in. The agency can dispose of the records after 60 days. Okay. However, the debt is still out there. Okay. Let's say it's $30. We granted your request. We generated the records. The charge is $30. Okay. Come and pick them up. Pay us when you come to get the records. The person never shows up. After 60 days, the agency can destroy the records. They don't need to hold on to them any longer. But the agency did everything it was supposed to do. It met all its legal requirements. That $30 debt is still out there. Well, that means a couple things. After 60 days, if the person wants the records, number one, they have to settle up on the first right to know request, okay, the $30. Then they have to submit a second right to know request for the same records, and that's going to be a second $30. However, let's say they want an entirely new set of records, something completely different from the first request. Until they settle up on the initial $30, the agency doesn't have to process any further requests from that individual because essentially their account is in arrears. Okay, now this only applies to right to know requests. If you're, in debt, if you're in arrears over your water bill, the agency can't deny your right to process right to know requests. It's only right to know requests. And there's no statute of limitations on this. It doesn't go away after a month, a year, 5 years, 10 years. As long as there is an outstanding debt for an unpaid right to know response, the agency has the option of denying all further right to know responses for that particular individual. Now, it is a denial, so it can be appealed. And like I said earlier with the other subjects, there is a body of decisions issued by our office related to outstanding debts. My advice to the agencies is make sure your I's are dotted and your T's are crossed. All documentation needs to be in order. You would keep, everything you sent to the requester, excuse me, how you calculated the debt, um, any communication, anything related to it that shows there is an outstanding debt and that debt is valid. Because if the person then appeals, the appeals officer is going to expect to see that documentation. And I can tell you that if everything's in order, 95% of the cases, if not higher, the appeals officer agrees with the agency. And they say, yes, the agency is correct. There is an outstanding debt here that needs to be paid before they're obligated to process any further right to know requests. And you take it from there. But just make sure, like I said, all your paperwork is in order and things will go along smoothly. And then finally, the right to know law does not address collections activities. We get asked this periodically. However you collect other outstanding fees, I would suggest you use the same processes for, any collection activities related to right to know law. Our office is not involved in any of that. Okay, you've kind of gathered this from some of my comments, no surprises. There is nothing in the right to know law that prevents agencies and requesters from talking to each other. Okay, agencies, if you get a right to know request, let's say it's a little confusing or a little vague, maybe it's written in legalese, the person's not an attorney, but they play one on TV, and you can't really understand what it is they're asking for, or maybe you're thinking, well, are they asking for this, or are they asking for that, because you know something that maybe they don't know. Pick up the phone or send them an email and get clarification. Same way with the requesters. I think this uniform state form that we designed here, I think that still has language on it that gives the requester the option of establishing a maximum cost. And it's completely legal. You can do that. For instance, you might write on the request, if this is going to cost more than $10, please give me a call. Okay, and that way you can have the conversation as to why it's going to cost more than $10, and then you can make a decision as to whether you want to spend more than $10 and take it from there. But what we're trying to say is that communication between the parties, number one, is it's not prohibited, and number two, it's actually a good thing, okay? Because you can save yourself a lot of aggravation by avoiding misunderstandings, okay? Now, if you've sat through the basics course, you know that one of the things that agencies cannot do is force a requester to tell them why they're seeking the records. But the law doesn't say the agency can't ask. And occasionally, that's the best thing to do, because you might get one of those requests that's a little unclear, and in order to help you identify what records are in question, you ask the person, do you mind telling me why you're looking for these particular records? Let me expand the example a little bit. The requester has a problem. Let's say they're a business owner and they're dealing with an IRS audit or something like that. The auditor has told them, look, if you're going to claim this deduction, you need documentation from the local jurisdiction. Let's say it's related to the building that they're in. You need documentation from the local jurisdiction, the township or the borough, that will help verify what you're claiming here. Now, the business owner has no idea what specific record they need, but they know that the township has it. So they submit a right to know request, and they write it using a very broad net, okay? I don't know exactly what I need, so I'm gonna just cast a wide net, and hopefully what I need is gonna come back to me in whatever they send. But the township is looking at this from the exact opposite paradigm. They want the request to be written as narrowly as possible to make their job easier. So the township, the arrow, if they're smart, will pick up the phone, have a conversation with the business owner, and say, do you mind telling me what record, why you're submitting this request and what records, you're actually looking for? So the business owner, realizing that, hey, this guy might be able to help me out because he'll save me money and he'll save me time, says, well, yeah, I'm being audited by the IRS. They say I need this documentation for me to claim this deduction on my business. Suddenly the arrow says, oh, I know exactly what you're talking about. That happens all the time. I can have that record ready for you this afternoon. Okay, problem solved, okay? The business owner's happy. The arrow now has far less work to do simply because they talked to each other. All right, so there's an example that, I'm just putting out there to explain that there's no reason why you can't have these conversations. Okay, it's just good public service and it results in less work for everybody. All right, I'm going to check the chat feature here. We haven't had any questions thus far. And I'm just making sure, no questions have come through yet. Okay, we're getting close to the end of the presentation, and I want to talk about certified records. Section 1307C in the Right to Know law it says something to the effect that agencies can charge a $5 fee per certification for certified records. Typically, this happens when someone is requesting records that will be admitted with litigation, with a court case. So those records need to be certified. The agency, in providing the certification, is not certifying the provenance of the records, the content. Rather, it is only certifying the fact that these are true and correct copies of the original. Okay, it's not like a police chain of evidence where you have to show who had, that it never left supervision. Rather, all you're doing is saying these records, these copies have not been altered in any way. This is what the originals look like, okay? And if you take a look at the Agency Open Records Officer Handbook that's available on our website, you download it for free, 78 pages. We actually have a page in there with sample language that you can use for these certifications. Okay, and I just want to reiterate, you're not saying that what is on the record is true and correct. You're only saying the copy that we're providing is a true and correct facsimile of the original. Transcripts. This comes up more often than you would think, where we have to explain to people this language, which I will do here after a sip of coffee. Okay, Section 707C. Someone will submit a right to know request for a copy of a transcript. The transcript is usually generated as part of a hearing. It may be like a building code violation that escalated. It might be a zoning hearing board, something like that. Wherever there is some sort of quasi-judicial meeting taking place where a legal decision ultimately is rendered. And there's a stenographer present. And usually those stenographers are private contractors. So this adds a new dynamic to the process. Section 707C details how the right to know law works in this particular scenario. And there are some conditions that have to be met before a transcript can be released through the right to know process. The first condition is fairly straightforward. All appeals have to have been exhausted. Meaning either it's gone all the way up to the Pennsylvania State Supreme Court, and sometimes maybe higher, to federal level, or one of the parties has opted, or both parties have opted not to appeal any further, and the appeal window has closed. Okay, that's the first condition. No more chance of appeal. The second condition is a little trickier, and that is that the agency, whoever is receiving the right to know request, must actually have a copy of the transcript. And that's not always the case, because many times with the stenographer, there's a flat fee that's paid just for the stenographer to come in and take the transcription. But then they hold on to the record, and the agency only requests a copy of the transcript if they need it for further legal activity, like if an appeal is filed. If it seems like whatever their decision is not going to be appealed, it's going to be accepted without any further litigation, they may have no need for a copy of the transcript. Thus, they would not be in possession of it, so they could deny the right to know request because they don't have it. And under the right to know law, you're not required to provide a record that you don't have. Okay, so the requester, the only option left for them would be to go to the stenographer and request a copy of the transcript. But then rather than pay up to 25 cents a page, they would pay the transcription fee, which typically is several dollars a page. Now, let's say that the agency did request a copy of the transcript and it was in their possession. Well, if they had it and all appeals had been exhausted, then it's a public record, and they would provide it through the right to know process, and they can only charge up to 25 cents a page. Now, the transcriptionist might get wind of this and raise a stink and say, wait a minute, that's my property, and I'm charging, let's say, $3 a page. Well, our office has said that no, it doesn't work that way. The agency paid for their copy. It's a matter of public record. The right to know law prevails. No more than 25 cents a page, because the transcriptionist has already gotten paid for their product when the agency purchased it. Okay, it's now agency property, not the transcriptionist. And don't fall for, the whole copyright thing. Occasionally they'll say, well, I'm copywriting it, so you can't make copies. That, like they say where I live, that dog don't hunt. Okay, it just isn't going to work. But that's how the whole thing works when it comes to requesting transcripts through the right to know law. Okay, we are at the end of the presentation. I haven't seen any questions. I hope the chat feature is working okay. I think it is. But as we're wrapping up here, if you do have questions, now's the time to get them in. I just want to bring your attention to our website. You've heard me say this before. It is the best government website you'll ever encounter. It has all kinds of resources available for you. Much of what I've talked about today, guides for citizens, guides for agencies. I mentioned the final determinations database. We also have a case law index if you want to see how the courts have ruled on the right to know law, as well as the Pennsylvania Sunshine Act, the Pennsylvania Open Meetings Law. If you're interested in further training, there are resources available on the website that you can take a look at. If you're a true geek when it comes to government transparency, you can subscribe to our X feed, and every morning at 7 a.m. we will wake you up with a tweet on everything that's, I guess they're still called tweets, but everything that's, fit for that day with the news on government transparency. And then finally, you can call our office, okay? If you have questions on the right to know law, we have administrative staff who are well-versed in the law, and we'll try and get you pointed in the right direction. But I want to thank everybody for your participation today. We will be back in 2 weeks with another topic, And in the meantime, take care, folks. We're going to sign off now.